In the criminal justice system, the people are represented by two separate yet equally important groups: the police, who investigate the crime, and the DPP, who prosecute the offenders. These are their stories. The prosecution will aim to expose jarring contradictions and inconsistencies within a defense witness's evidence. The defense will similarly aim to do the same. To extract crucial information to build her case theory, the Crown Prosecutor begins by asking many open-ended questions during examination in chief. The witness is able to provide an untainted account of his story. Should leading questions be asked during examination in chief, the defense may object under Section 37.
What happened then?
I saw Mr. Ruka walk towards the Holiday Inn Hotel, towards Mr. Zarika. One of the men went inside the hotel while the other stayed outside and left.
Do you remember who that man was?
He may have been Mr. Zarika. I don't remember.
Did you enter the lobby of the Holiday Inn Hotel?
No, I don't think so.
Did Constable McKibben ever enter the Holiday Inn Hotel?
No, I don't recall, but I don't think so.
Then what happened?
I've forgotten most of what happened, and I only made my statement 3 months after. Constable Bell's account of events contradict the evidence given by Constable McKibben. Did the policeman follow Mr. Zarika into the hotel lobby? Did Constable McKibben ever hear the incriminating words spoken by Mr. Zarika? The Crown rests a voir dire invoking Section 189 of the Uniform Evidence Act. The jury are asked to leave. Where two contradicting accounts of events are laid out, the prosecution is pushed to make a choice as to which it would like the jury to favour. Section 38 frees the prosecution firstly from the chains of Section 37 and secondly the Sections 102 as a consequence of Section 103. Should a Section 38 be granted, she will be allowed to question her own witness as if in cross-examination. This will allow her to attack Constable Bell's evidence and discredit his account of events in favour of Constable McKibben.
Constable Bell has a poor memory. There are important inconsistencies between the evidence of Constable Bell and that of Constable McKibben. We seek an application under Section 38 as the evidence is generally unfavourable to the Crown. We submit that he has a faulty memory.
Counsel, there is a difference between inconsistent and unfavourable. One would expect that the training and experience Constable Bell has as a policeman ought to have him able to give evidence to at least the events. Different evidence does not raise the view that his evidence is unfavourable.
As we observed, the definition of unfavourable witness is a complex one. In the Adam and Lozano cases, it was identified that unfavourable may be taken to mean a witness who has no recollection of a lot of things. The Crown Prosecutor in this case is undoubtedly relying on Constable Bell's self-proclaimed forgetfulness to get her over the line for a Section 38. The judge draws a distinction between inconsistency, that is, contradicting evidence between multiple witnesses, and what is unfavourable. We see that Constable Bell, although forgetful, is a policeman, someone who is expected to be able to provide a rough sequence of events, if not a detailed one, when called to do so. This is part of his profession. What this encounter illustrates is whether a layperson who is not a policeman would be treated in the same manner. As seen in the existing case law, and as stated in the Uniform Evidence Act, a witness who is unfavourable or appears not to be making a genuine attempt to give evidence on matters he or she is reasonably supposedly to have knowledge about may be cross-examined by the party that called them. Although Constable Bell asserts on multiple occasions that he had a poor memory, the judge does not grant a Section 38. Perhaps much of this does rely on the fact that he is a policeman, and that a higher standard is expected of them. The jury are called back in and the trial continues. A trial like the one described was estimated to last 3 days, over which the jury would be asked to leave and re-enter the courtroom on countless occasions, much like the one described above. This fragments the trial process and makes it difficult for the jury to comprehend what is happening or why something is happening. In the described scenario, the judge allowed the evidence to be admitted and no Section 38 was granted. Following the voir dire, the judge could equally have given a direction to disregard Constable Bell's evidence. The judge has the discretionary power to give any leave, permission or direction on such terms as the court sees fit, under Section 192. Even if the judge did so, it raises another issue for the jury. Should this have occurred, imagine how befuddled the jury would be. The judge had already heard the evidence. Being told to disregard it does not mean you can automatically switch it off. Once heard, evidence may still influence the decisions of jurors to a certain extent.